Good morning, this is your Kelso Report for Wednesday, April 4th, and I'm your host, Clark Kelso. Today we have cases from the Ninth Circuit dealing with habeas corpus and immigration, and some criminal law cases from the California Court of Appeals. We begin with the Ninth Circuit, the habeas case. In 2003, the petitioner pleaded guilty to using a firearm in relation to a drug trafficking offense in violation of 18 U.S.C. Section 924 C1A. 4 years later, in 2007, the Supreme Court decided Watson v. United States, which held that a person who receives a firearm in trade for drugs does not use the firearm for purposes of Section 924. Now, Watson left intact a prior Supreme Court holding that a person who supplies a firearm in exchange for drugs does use the firearm for purposes of Section 924. So the application of Section 924C depends upon whether the person supplies the firearm, in which case it's being used, or receives the firearm, in which case it's not being used, in trade for drugs. The petitioner filed his habeas petition after Watson, alleging a claim of actual innocence, since he now asserts he received the firearm in his drug transaction. Well, the district court denied the petition, and in Muth v. Fondren, the Ninth Circuit affirmed. The problem in this case is that the indictment described the crime with the petitioner bringing the firearm and trading for drugs, while the plea agreement described the crime with the petitioner bringing the drugs and trading for the firearm. So it sounds like there's an ambiguity and a conflict. Well, unfortunately for the petitioner, he actually pointed out the inconsistency between the indictment and the plea agreement when his plea was being taken. And he testified under oath that the plea agreement was wrong, and that he brought the gun and traded it for the drugs. So given his own testimony, the Ninth Circuit rejected his claim of actual innocence and affirmed the district court's denial of a requested certificate of appealability. Next, an immigration case. In Arbid v. Holder, the Ninth Circuit upheld the Board of Immigration Appeals' decision that the petitioner had committed a particularly serious crime, rendering him ineligible for asylum or withholding of removal. The court also upheld the board's determination that conditions had so changed in Lebanon that it was no longer more likely than not that the petitioner would be tortured upon his return. On the finding that the petitioner had committed a particularly serious crime, the Ninth Circuit panel held as a matter of first impression in the Ninth Circuit that the board's determination that a conviction was for a particularly serious crime was an exercise of discretion subject to an abuse of discretion review. The court concluded that the board considered the appropriate factors in determining that the petitioner's conviction for mail fraud arising out of a complex scheme to defraud victims of nearly $2 million constituted a particularly serious crime. Next, we turn to the California Court of Appeal in a criminal law matter. The defendant in People v. Finney was convicted by jury of assault with a deadly weapon with findings that he personally used a deadly weapon and inflicted great bodily injury on the victim. In a bifurcated trial, the trial court found that the appellant had suffered 2 strike priors and a prior prison term. Appellant then was sentenced to state prison as a 3-striker for 29 years to life. On appeal, the defendant argued that his 2 prior strike convictions should only have counted as 1 strike. The Second District rejected this argument. Back in 1999, the defendant had been convicted for mayhem and assault. He pled guilty to the charges, and the trial court explained to him that you now have 2 strikes. The first strike was for beating the victim and leaving him for dead. The defendant fled, but then returned 30 minutes later and kicked the victim in the head 3 more times. That was the second strike. The Second District reasoned that there was a sufficient break between the first assault and the second assault to constitute 2 separate incidents for purposes of the 3 strikes law. Next, the defendant in People v. Gray was convicted by a jury of running a red light based on evidence provided by a red light camera. Before a local jurisdiction may issue traffic citations utilizing an automated traffic enforcement system, it must issue warning notices for 30 days before issuing citations, and it must make a public announcement of the system at least 30 days before commencement of the program. Well, Culver City provided a 30-day warning notice period and public announcement when an automated equipment was placed in operation 10 years ago. The defendant argued that Culver City should have provided another 30-day warning notice period and public announcement when the equipment became operational at the specific intersection where the defendant's violation occurred. The Second District rejected the defendant's argument, holding that a local jurisdiction need only provide one 30-day warning notice period and one 30-day public announcement before beginning to roll out the system throughout the jurisdiction, and that it does not need a new notice period of announcement before the installation of the system at each intersection. Now, this holding does bring the Second District into conflict with a 2010 decision by the Appellate Division of the Orange County Superior Court in People v. Park, which held that a new notice and announcement was required for each intersection. Because of the pervasive use of automated traffic enforcement systems around the state, I think there is a decent chance we might see this issue taken up by the California Supreme Court to give us a definitive resolution. And that's it for today's Kelso Report. Drive safely out there and have a great day in the law.